Hello everyone and welcome to today's seminar. My name is Susan Dowdy and I am one of your ICC Government Relations Managers here in California. Today we have a seminar entitled California Code Adoption for Local Jurisdictions. I'd like to introduce the seminar with three important points. First is the International Code Council, ICC, is the organization that facilitates the development of 15 model codes, including the International Building Code, the IBC, the International Residential Code, the IRC, and the International Fire Code, the IFC. Two, the California Building Standards Commission, the CBSC, is the California agency responsible for establishing the California Building Standards Code. And finally, three, local California jurisdictions can adopt local amendments to the California Building Standards Code as needed to protect their communities. We are very fortunate today to have two excellent speakers. First, we have Mia Marbelli, the Executive Director for the California Building Standards Commission. She comes to the Commission with 20 years of prior state experience after joining the Commission in 2012. In 2016, she was appointed as the Executive Director. She keeps very busy overseeing the adoption, approval, publication, and implementation of the California Building Standards Code. And we also have Stuart Tom, who is on the ICC Board of Directors, as well as the IAS Board of Directors. He has extensive knowledge and experience in the code profession, including being a fire marshal for the city of Glendale, and that was after 16 years of being the building official for the city of Glendale. He is a registered engineer in multiple states and a member and participant of numerous code-related committees and activities. This webinar addresses the local code adoption process in California. With the new codes being adopted and published for California, local jurisdictions have an opportunity to complete local adoption ordinances and file them with the California Building Standards Commission. I'd like to take this opportunity now to let you know the process for submitting questions if this option is available. At any time during the presentation, please type your questions into the Q&A portion of the Adobe Connect box. The facilitator will respond to your questions at the end of the webinar. There are some objectives that will be met with this seminar. Upon completion, participants will be able to identify the California codes in Title 24, describe the local code adoption process and legal authorities relating to the process, describe the California code adoption timeline, including local adoption timeframe, describe the common mistakes frequently made with local code adoption. So now we're going to get into the seminar, but before we do that, I would just like to pose some questions that I know Mia and Stuart will be handling. So is it really time to adopt another code? Haven't things settled down since we've been using the I-codes for a while now? Is California proposing many changes to the model codes? How much of my current locally adopted code will be reusable? I think I know what I'm doing. Have I been doing it right?
We'll start by talking very briefly about the codes that we're going to be adopting today for the next 3 years. First off, I want to point out that the codes that local jurisdictions will be adopting will be the California Building Standards Code. I do want to point this out because some jurisdictions think that the codes that they will be adopting are the international or model codes. That's not actually the case. The state of California, as Mia will be explaining later on, adopts for the entire state the code that will be applicable unless the local jurisdictions have a need to make those local modifications. And with that, Mia is going to talk about some of the local adoption process and legal authorities that you are all empowered with to make those changes.
The state law authorizes the local jurisdictions to make their local codes more restrictive than the California codes, but there's a process that's gone through for that. And we'll get into the state laws that are required and necessary, and then also get into what's necessary in your local ordinance, like express findings, and expressly marking the changes that are necessary so that folks can identify what their local jurisdiction is enforcing.
And there's a timeline. It's actually a two-part timeline that we're going to go over so to help you really understand how the codes were adopted for California, and then where as local jurisdictions you need to be. Mia will take the first part, and she will explain all of the steps that the state goes through in order to establish the California Building Standards Code. And then I'll take the second part where we get to take a look at where we are today, where we need to be in order for those codes to be amended and take effect for your local jurisdiction starting January 1st, and what we all need to do in order to get there.
We'll also talk about what's new in the 2019 edition of the California Building Standards Code. There are not a lot of changes. If you are already comfortable with what was in the 2016 intervening code cycle, many of the code provisions were early adopted in the intervening, and so if you're familiar with what was in the supplement, that's pretty much what you're going to be enforcing in the 19 code as well, but we'll go into greater detail.
And then most important, we're going to go through some examples to show you how code adoption justification is actually done. We'll show you some really good ideas that if you are not doing it for your jurisdiction right now, you may want to consider it. And we'll talk very briefly about some common mistakes that some jurisdictions encounter while they go through the process.
So what is Title 24? It's the 24th title in the California Code of Regulations. There's actually 28 titles in the California Code of Regulations. And the California Code of Regulations is set up into disciplines, and it's also set up by state agencies and subject matter that different state agencies have authority to promulgate regulations in law, or promulgate regulations. And so Title 24 is reserved specifically for building standards. And so within the law, different state agencies have authority to amend. What we do is adopt model code. As you know, it's published every 3 years, and it's comprised of 13 parts. One part is currently not used, and I'll go through those for you. The first part is the California Administrative Code. It primarily is comprised of state agencies' authority for fee structures for schools, and the authority that different state agencies have. It's not very used very often by the local jurisdictions, but it is important for OSHPD, State Fire Marshal, DSA, and the Building Standards Commission. It also lays out the administrative process by which the building standards are adopted and amended in California. Most of you are familiar with Part 2, which is the California Building Standards, the California Building Code. And it is actually comprised of 2 volumes. Prior to this cycle, parts 8 and 10 were also included in there, and that's going to be a change this cycle. We'll talk about that a little bit more. Part 2.5 is the California Residential Code. Part 3 is the California Electrical Code. Part 4 is the Mechanical Code, and of course Part 5 is the California Plumbing Code. Part 6 is the California Energy Code, which is only developed by the Energy Commission. It's not based on the model code. Part 8 is the Historical Building Code. Part 7 I missed is vacant, and Part 9 is the California Fire Code. Part 10 is the California Existing Building Code. Part 11 is the California Green Building Standards Code, and Part 12 is the California Reference Standards Code.
So let's start by looking into what gives all of you as local code officials the authority to take California's Building Standards Code and amend it, make it different for your jurisdiction. There are a lot of statutes that are involved, but 3 in particular have the bulk of the authority that is granted unto all of you to make those changes. In the Health and Safety Code, section 18941.5 establishes the standards by which you are allowed to make changes under what's called the Building Standards Law. Also in the Health and Safety Code, section 17958 is the State Housing Law. That's what empowers you to make those changes to Title 24 that are directly related to housing within the state. And then the third really important statute is Health and Safety Code Section 13869. This is the section of the Health and Safety Code which authorizes fire protection districts to make changes to the standards that protect fire and panic safety to see to it that your communities are protected.
Also, the local jurisdictions must enforce the current code, and that is the California Building Standards Code for local enforcement, and they must do it within 180 days after the code is published. And the effective date this year is January 1 of 2020. If you are adopting Title 24 for local enforcement, the jurisdiction may amend those standards and make them more restrictive, as we talked about. If you do not make them more restrictive and you do nothing and you stay silent, you do have to enforce the most correct code. There's also some additional authority in law beyond what Stuart just mentioned. I've listed them here. I'll give you an example. If you make an amendment to the California Historical Building Code, you may need to file that with the State Historic Building Safety Board. And also a more recent change to the code is an appendix that's available for local jurisdictions to adopt for emergency housing. That was developed by HCD, Housing and Community Development. If you've determined that you have an emergency housing crisis in your area, you can adopt these appendices, and you would file those with HCD. Now, oftentimes the Building Standards Commission receives all of the ordinances, and we forward those along to the other state agencies as appropriate. We've developed a guide that complements this video, and in that guide it has a list of all of these laws, and it also has a listing of the addresses and the information to get a hold of the appropriate state agency. All right, I'd like to touch on administrative standards versus building standards. The key here is Chapter 1 has many administrative standards that local jurisdictions use in their to set permit fees, set filing requirements and whatnot. And if those are amended and they implement or enforce a building standard, it may be necessary to provide findings and expressly mark that. I will tell you that in Health and Safety Code 18909, a building standard is defined as a regulation or a rule relating to the implementation or enforcement of a building standard not otherwise governed by statute. So you need to be very careful about amending the administrative standards. And it is, if you do not amend the administrative standards and you're adopting those, it is not necessary to file an ordinance that contains findings for those. There's other items in the codes that you may want to be familiar with that aren't actually enforceable, and that is the matrix adoption tables. Those are there for reference. They have X's that talk about the state agency's authority and who's amended or adopted specific chapters or sections. And it's very careful to pay attention to those. And they are there for reference, and they oftentimes can have minor mistakes, so it's important not to maybe reference your ordinance off of those, but actually amend the codes themselves. I'd also like to talk a little bit about the appendices. Some of these are enforceable at the local jurisdiction. Some of them are automatically part of Title 24, and some of them actually need to be adopted by the local jurisdiction, and we'll go into a little bit of detail there. Okay, so the timing here. Title 24 is going to become effective January 1. It's going to be published this July. And what that does is allows you about 180 days to get your ordinance ready for filing. If you choose not to file an ordinance, you then must comply and enforce the base model code, or the base California code that has been adopted by the California Building Standards Commission.
One of the things that I wanted to talk about in terms of the local code adoption process was your local jurisdiction's actual process. Every jurisdiction does it slightly differently. Some jurisdictions like to conduct public meetings in order to allow the stakeholders to share their thoughts and concerns regarding what's important for their own adoption. So give some thought to what your jurisdiction does this cycle when you take on the effort of adopting your code. Do you want to have those public meetings to discuss some things that perhaps your jurisdiction has been thinking of integrating into the codes? Certainly, you're going to have at least two very important activities in order for your governing body, whether it be a city council or a county board of supervisors, to adopt a local ordinance. Since this will become local law for your jurisdiction, you're going to have two readings of that ordinance before the governing body can adopt it. A first reading where it's first presented, and then a second reading after any potential input has been received by those local officials to actually adopt the ordinance and bring it into law. But then in addition to that, does your city hold preliminary meetings in order to get that stakeholder input? These days, transparency is very important. And rather than just pass new laws that will affect your community without hearing from the community first, most jurisdictions are having opportunities to allow their stakeholders, whether they be residents, builders, architects, designers, and so forth, to share their thoughts regarding what might be valuable and important for inclusion in your local adoption ordinance. And we'll talk about that briefly.
Well, let's talk about how we got this far. So the code adoption process starts with the publication of the model codes. And California is required to adopt the model codes, and they're developed by the International Code Council, the International Association of Plumbing and Mechanical Officials, and the National Fire Protection Association. And then in addition, California also develops and adopts its own California codes, such as the California Energy Code, the Cal Green Code, which is the California Green Building Standards Code, and then also the California Administrative Code, and the Historical Building Safety Code. But the timeline started quite some time ago. I know this is a small detail, but I'll go into the steps here in a minute. So once the codes are published, the state agencies begin looking at the changes in the current model code, and it may be necessary for them to conduct workshops if they're doing complex changes or difficult changes, and that's the first phase of the rulemaking. And then once they've developed the language and the rulemaking documents, which I'll go into in a minute, they submit what's called an initial submittal to the California Building Standards Commission. And that's where our role steps in and we administer this process. So the next step is the code advisory committees. There's actually 6 code advisory committees that are comprised of up to 9 members each. Those are nominated by the commission, and they conduct public meetings where they actually review all of the proposed code changes, and they weigh them for their technical merit, and they provide recommendations to the state agencies and also the commission on whether they should be approved, amended, set back for further study, or disapproved. Once those meetings have concluded and the recommendations are complete, a public comment process is conducted, and it's at minimum 45 days. And at that time, the public submits comments to our office. We forward those on to the state agencies, and then the state agencies have an opportunity to either accept those comments and make additional changes to the regulations, or they may move forward with the language as is. After that, the state agencies submit to the Building Standards Commission what's called a final rulemaking package. And this is what's presented to the commission at a public meeting. And this is where the public has the opportunity to speak again on the proposed regs. And this is where the commission actually makes its final determination on whether to approve, disapprove, further study. And then once that's done, that's where we begin the codification process. So that's what we've just wrapped up. So it takes about 6 months from the time the commission approves the regs to the time in which they're published. And that's where we work very closely with the publishers, going back and forth with proofing. And then ultimately this July, they will be available for purchase. And then finally now here we are in this 180-day wait period. And this wait period is where you have the opportunity to develop your local ordinances and get them filed with us. Generally prior to the end of the year, but if they are filed after the end of the year, that's okay too. You just need to keep in mind that you can't enforce those unless they're filed with our office. So the effective date, as we know, is January 1, 2020. After that, there may be erratas or supplements that are issued over the next 3 years. We always have an 18-month intervening code cycle where the blue pages that you receive are the supplement pages. The erratas are buff in color, and they can come at any time because they make grammatical or non-substantive corrections to the code. I would like to talk about the rulemaking documents just a little bit so you understand the terms that we use. And this comprises a file from each state agency for each part of the code. So for example, the Department of Housing and Community Development, if they were amending Part 2 of the building code, they would be submitting all of these documents for just that part. This last cycle, this Building Standards Commission received 45 rulemaking packages from the various state agencies. So you can see the significant amount of work that goes into each triennial cycle. So the rulemaking documents are the express terms, which are the regulatory language that you see that is in strikeout and underlined, showing you what is being removed or added to the code language. The initial statement of reasons gives the why. Why is this happening? How will it affect me? Is it necessary? Each state agency has to justify each change they're proposing. The Notice of Proposed Action is a formal document that is actually filed with the Office of Administrative Law, and that notices the public comment period, and it also has information on cost effectiveness, the benefits, and the effect on the regulated community. And then the 9-point criteria is what is the state is determined that this meets this criteria and therefore is acceptable for the commission to approve. And then the Form 399 is an economic and fiscal impact statement. It's required by the Department of Finance. Anytime a state agency in any title of the California Code of Regulations develops regulations, they must submit a 399 to the Department of Finance. I want to reiterate that all of these documents may be modified throughout the different phases of the rulemaking, and at all times they are available on their website and they must be made publicly available. So we have another guide. It's a public guide to building standards adoption process, and it can give you more detailed information about the process, about other required documents, and then also how to contact us if you have questions.
Okay, at this point, I'd like to go through a second timeline. This timeline actually gives an idea of what you, as local code officials, will need to do in order to see to it that your locally amended code is ready for enforcement starting on January 1st. As Mia pointed out earlier, there's the timeline that the state follows in order to take care of all of the work in the rulemaking process to move from the model codes to the California Building Standards Code, or Title 24. Once that is done, you as a local code official take up the rest of the work to take the California Building Standards Code, or Title 24, to the point where it is your locally enforceable set of codes. And this timeline right here is going to show you the steps that need to be taken and where you need to be, and will give you an idea of how much time you have to do all of this. So Mia took the state process up to effectively July 1st, because at that point, the California Building Standards Code, Title 24, is available for all code officials to get a copy of those codes in their hand. But ultimately where we want to be is on the far right end of this timeline, where there will be a new code effective and enforceable for your jurisdictions. So to get to that last step and figure out what those timelines are, the easiest way to handle it is to work backwards. So, as I mentioned before, Mia and her staff at the Building Standards Commission has already done most of the heavy lifting in getting the model codes to Title 24. That took us to July 1st. That was the point at which the California Building Standards Code was available for all of us code officials. What we're really interested in, however, is getting all the way to January 1st, because that's the date at which we as code officials intend to be enforcing the next set of codes for our jurisdictions. So let's see what's involved in that 180-day period of time during which code officials can take the Building Standards Code and make those necessary changes, those local amendments, to bring the code to what you want to enforce for your jurisdictions. This is that period of time during which those changes may be made, as long as you can properly justify the necessity for those local amendments on the basis of a local geologic, topographic, or climatic condition. The first date that shows up if we work backwards on our timeline is November 26, 2019. Let me tell you what the significance of this date is, because it may be different for your jurisdiction. In this example, in the examples that I'll be using for today's session, I'm utilizing a jurisdiction for which their local governing body, their city council, meets every Tuesday. Okay? So since for this jurisdiction, their city council meets every Tuesday, November 26th of this year will be the very last Tuesday for which there is 30 days or longer between that meeting and January 1st. The reason that this becomes important for all of you is that your governing body has to pass that ordinance with at least 30 days before it becomes effective. It wants to avoid the necessity of appending an urgency clause to that ordinance. Now, because there is plenty of time in order to take this action, there's really no need for your city council to try to justify the need for an urgency clause. And so to avoid that, I want to make sure that there is at least that 30-day wait period before that ordinance becomes effective. And once again, since in this example, the city council meets on Tuesdays, and November 26th is the last Tuesday prior to January 1st with at least 30 days. This is the date that that city council must pass that ordinance if I want to meet that January 1st effective date. Still moving backwards, the next important date is November 12th of this year. How did I pick that date, and how will your jurisdiction pick your date? Well, since city councils in this jurisdiction meet on Tuesdays, this date is 2 council meetings prior to the date that I expect them to pass this ordinance. I could have chosen the Tuesday immediately before, but it is prudent to give yourself a little bit of a cushion because things happen. And so I chose 2 city council meetings prior to the date I want them to adopt the ordinance, and this is the date that I'm going to target the first reading of this draft ordinance. The reason that a 1-week cushion is very important is that the month of November is one of the busiest months for most communities, and oftentimes your city council goes dark, either because of the holidays, Thanksgivings near the end of November. Things can come up, and if for some reason your city clerk chooses to take that item and continue it, the schedule could be off, and I might not be able to get to city council 30 days prior to January 1st. So therefore, I add a 1-week cushion, and this date, November 12th, is the last Tuesday that I can safely bring my council the draft ordinance for its first reading. Still moving backwards, let's take a look at the next critically important date for you as a code official. In this example, I'm putting October 16th on the timeline. The reason that I'm doing that is most jurisdictions are choosing to have an open process where they let all of the stakeholders know what they're doing. In this particular example, the city that I'm using has a Building and Safety Commission, and they meet once a month. It turns out that the last time that they will meet prior to that November 12th date is on October 16th. And so if I expect to have an opportunity for that board to make a recommendation to the city council to adopt the ordinance as discussed and presented to them publicly, I have to have them take that action on that particular date. Okay? And just like it's important to go before your city council twice, it's also important to hold your public meetings in that manner so that you can present the draft ordinance one time, give an opportunity for everybody in attendance to give you their feedback, their thoughts, comments, and so forth regarding your draft ordinance ideas. And so since in this example, this community has their Building and Safety Commission meet once a month, it turns out that prior to that October 16th date, September 18th is the scheduled meeting prior to that. So this then becomes the very last date that on a regularly scheduled meeting of the Building and Safety Commission, this jurisdiction would be able to open to the public an opportunity to see for the very first time the draft local amendments that I have in store for my community. This is the date that I would hold a public meeting, present the package, allow some input, then give those stakeholders one full month for them to come back later on in October with any suggestions that they have. And I would hope that at that time, the commission concludes that public meeting with a recommendation that I would then be able to submit to my city council.
One of the things I forgot to touch on earlier, and I think it's appropriate now that Stuart's gone through the arduous process that the local jurisdictions have to go through to adopt the local jurisdictions. I think it's key to understand here the amount of time, energy, and the variety of people that are involved in this process. So just to get the codes published, I went through the extensive process that we do, which involves the public members, the model code developers who are very vested in developing model codes for this country and internationally as well. The public members, which there are a lot of that are very involved in contributing to the local adoption process and also the code adoption process. And then the code advisory committees that are very well versed in the code use and very interested in making sure that the codes are enforceable and effective and safe for our community. So the Building Standards Commission and the Building Standards Commission staff want to really extend our thank you to all of you that contribute to this process, because it would not be possible without this very effective public process. So with that, the July 1 date is really a handoff to you folks, as Stuart has gone through. And there's really not a lot of time. 184 days sounds like a lot, but there's really only 126 days, as Stuart pointed out, that are working days. And then you take out all the holidays and everything, and we're kind of limited in what we can do.
At this point, using those dates that I put on the timeline for you before, the amount of time that code officials actually have to get the work done shrinks even further. As Mia just pointed out, the amount of time between July 1st, when code officials first get their hands on that code, until January 1st, when it becomes effective, there were only those 126 days that she mentioned to get all this work done. But remember, November 12th was actually the last date that I could safely get to my city council with the first reading of an ordinance. And so if I have to have that ordinance already drafted to present to my city council for the initial reading on November 12th, that leaves only 134 days. But if you take away weekends and holidays, you're down to 92 days to get that package to your city council in order for them to take action. And as I mentioned before on that timeline, September 18th was a critically important date, because if your jurisdiction tries to be open and transparent, and if you're going to have opportunities for the public to share their thoughts and concerns regarding adoption of laws that may affect them, if you have opportunities for public meetings, September 18th was the very last date that I could utilize that jurisdiction's Building and Safety Commission to present the draft for the very first time, so that I could follow up the following month in October to have them give their recommendation that the City Council adopt those provisions. So if I use that September 18th date as the date that this jurisdiction, and your jurisdiction might have a slightly different date for its public meetings. What we really have is only 79 calendar days to get this work done. If you take out weekends and holidays, that leaves only 55 days between when you get that code in your hands on July 1st to when you have to be ready to start those public meetings in order to allow your community to have a say in what codes and laws are going to affect them. So, what do local amendments look like? First off, just follow the same format as Title 24. It is best to use the same section numbering scheme that Title 24 currently uses, so that the new code amendments, whether they're additions to the code or alterations to the code, follow the same sequence that the California Building Standards Code follows. But that's not always necessary. Some jurisdictions actually adopt their own municipal code standards, and in order to be consistent with the code sections that they have in their municipal code, the numbering is slightly different. And if that's the case, that's all right. Just follow that numbering scheme as well. But if you don't have to change the code section numbering in order to meet some other codes or standards that your jurisdiction follows, the best recommendation is just to use the same format as Title 24.
And just a reminder, amendments to Title 24 may not be less restrictive than the base model code. They must meet California code. So your jurisdiction may want to ease up on certain things. We can't do that with local amendments. There is some more flexibility, though, in the changes to the administrative standards, so feel free to amend those as necessary.
And Mia, don't you have an example?
I do. Local jurisdictions may want to increase the wildland urban interface standards in their jurisdiction. Keep in mind that the model code, not the model code, the state code has 7A, chapter 7A in the building code, and it also refers to the public resources code, and it also refers to the health and safety code. So you must follow those, but you can add to those and make them more restrictive, and you can add more additional information to make your local jurisdiction safer in those areas.
Perfect. So we just talked about local amendments and what you need to do in order to get your ordinance adopted. But what do the justifications for those local amendments look like? Well, generally, the best format is to simply utilize clear, simple text that explains why you believe that a local amendment is reasonably necessary to protect your community on the basis of a local geologic, topographic, or climatic condition. But keep in mind, it's not acceptable to merely state that an amendment is necessary due to a local geologic condition. You actually have to express what that geologic condition is.
And each requirement, each amendment does require a justification. You can't merely lump a bunch together and add one justification for that group. You must clearly cite each one separately. And a justification does not need to be unique to your local jurisdiction. You may be in an area where several jurisdictions have similar conditions, and you can cite that similarly to other areas around you.
And we have some examples that we're going to go over later on in this program.
Okay, so let's talk about the state agencies that amend the codes. Generally, what you're going to see is these are the most common state agencies that will affect the codes that you're enforcing for your local jurisdiction. The Department of Housing and Community Development is one. The State Fire Marshal is another. DSA for Access Compliance. And OSHPD 3, which is Office of Statewide Health Planning and Development. And 3 is their clinics. And clinics are overseen by local jurisdictions, unlike the hospital provisions that OSHPD has. And we have another guide that has detailed information about the authority that each state agency has to amend the codes and how that's done. And it also goes into great detail about the matrix adoption table, which I'll talk about in a minute. If you would like to see this guide, it's the guide to Title 24, and we do refresh these every 3 years. Sometimes we add changes in between, and we have a revision number on that. And you can find it on our website. So these state agencies, these are the banners that you see in the code provisions with the brackets around them. So BSCCG stands for the non-residential green standards provisions that the California Building Standards Commission has authority for. And they're banners generally sprinkled out throughout the code, and primarily they're pointers to the Cal Green Code. And then HCD1 is for hotels, motels, apartments, condominiums, and single-family dwellings. HCD2 is for their mobile home park program. And then State Fire Marshal, this is really broadly amends the codes, and it has to do with fire and life safety provisions for almost all occupancies, but also hazardous material storage and those types of things. And then DSA access, as you know, is completely for accessibility, and that must be incorporated in all plans and drawings for the state of California. And as I talked about, OSHPD 3 is for licensed clinics and outpatient services.
So let's talk about the actual process of ordinance adoption. What are the key elements of a local code adoption ordinance? We're going to go over some examples in just a bit. Is there a particular format that must be followed? I'll go over an actual example of an ordinance that was adopted by a local jurisdiction here in California. And can all the codes be adopted in a single ordinance, or is a separate ordinance required for each component, whether it be the California Building Code, the California Residential Code, the California Fire Code, etc.? It's really up to the jurisdiction. Some jurisdictions do separate ordinances for each component of Title 24, others just lump it all into one, and both ways are acceptable. It's whatever is familiar to you as a code official and whatever is easiest. How important is it that local jurisdictions adopt similar codes? And is bigger and stronger always better? I want to take an opportunity to address this because I do know that here in California, many jurisdictions are taking steps to simplify their codes, and if it is reasonable and possible, to adopt codes that are much more similar to those by their neighboring jurisdictions. Keep in mind, this really is important because we are serving the local builders, local designers, and so forth in our jurisdictions. And if the codes that we as code officials adopt for our jurisdictions are substantially different than those that are adopted by the jurisdiction right next door, that could cause some difficulty in terms of development. So if it is possible to adopt codes that are sufficient to protect your communities while at the same time being very similar to those codes adopted by your neighboring communities, that is beneficial to the community. In terms of is bigger and stronger always better, while there is a desire by some communities to outdo neighboring communities, I would like to suggest that you really give that some thought before you go down that road. While it is important to do everything that you can to provide codes that reasonably protect your community, if it is not critically necessary to come up with standards that outdo your neighboring jurisdiction, sometimes avoiding that could be looked at as an effort to work closer to your constituency. So, does code adoption present an opportunity to improve your local codes, and should you improve your local codes? This is the reason why code officials are doing what they're doing. Take a look at the California Building Standards Code that are presented to you, because that is the law of the land. You can already enforce that as MIA's staff has already adopted for you. But there are some other areas that you may want to consider, because due to local conditions and certain characteristics of your community, you may feel that it is necessary to look at certain provisions within Title 24 and make those adjustments. WUI standards, grading and drainage standards, prescriptive simplification of the code. Are there ways that you can make the code easier for your customers to use? Adoption of the appendices. Are there some appendices that are not adopted into Title 24 that could be useful to your community? And then adoption of specialty codes. For example, the International Swimming Pool and Spa Code. And there are some other codes that we'll talk about later on that may be of interest to you. There could be some opportunities during this code adoption time where you can take a look at the codes that are provided to your jurisdiction by the state and determine whether or not there are opportunities to improve the codes to better protect your communities.
So let's talk about your ordinance once it's filed with our office and what we look for. It must be adopted by your governing body, and we look for the stamp and the date and the signature that was conducted. Additionally, all amendments must be adopted by ordinance, and it can't be a department policy. It has to be, that will be sufficient. It's really important that if you're a contract city, that you file your own ordinance with our office and not be defaulted into a larger jurisdiction. In order for you to enforce those amendments, you have to file that with our office. And additionally, it must include the standards that will be amended, as we've talked about, expressly marked, and all of the findings for each expressly marked change. And if you're going to amend the Green Building Standards Code or the Energy Code, you must include justifications for that. And then amendments must be reasonably necessary, as we've talked about, for the local climatic, geological, or topographical conditions. Let's talk a little bit about appendices. Many of the notes on the appendices can be a little bit confusing or misleading, and we want to clarify that. And there have been some changes this cycle as well. So it's very careful to read the note that's underneath the title of the appendice. And then also the note that's underneath in this example, it's Appendix G, flood-resistant construction. It's not a part of Title 24 unless adopted by a state agency or a local jurisdiction. And you can see here that no state agency has adopted this in the commission, in the matrix adoption table, excuse me. Another example here is Appendix C for Group U agricultural buildings. The state fire marshal adopts the chapter, but the note says not mandatory unless specifically referenced in the adopting ordinance. So the state fire marshal has adopted this, but if you want to utilize this appendix, you must include it in your local ordinance. And then here's another example. This is not mandatory unless specifically adopted by a state agency or referenced in the adopting ordinance. And note that HCD has adopted the entire chapter, but the state fire marshal has adopted only specific sections of that chapter. And then I think this is the last one. I talked about this earlier about the emergency housing. This is new to the code. HCD proposed these as emergencies about a year and a half ago, and now they're blended into the 19th edition of the code. But keep in mind, it still must be adopted by a local jurisdiction in order for it to be mandatory and enforceable in your area. Okay, so there really aren't, as we talked about, a lot of changes in the 19th edition of the California Building Standards Code. Because what happened in the intervening cycle is the state fire marshal and HCD and several other agencies early adopted some of the 2018 code provisions. And now those just become part of the 19 code. So what happened during the rulemaking is the state agencies actually repealed that language, and then we automatically adopt the model code. So if you're very familiar with what was in the supplement, you'll be enforcing the same provisions in the 19 codes. One change you'll see is the 2018 International Building Code. There were some chapters that were reorganized, and so the state agencies followed suit, and so that part 10, has actually changed significantly. So pay close attention to that.
So at this point, let's go through some important elements of the adoption itself. Some of these are things that most jurisdictions are aware of, but some code officials may not be aware of how important these are. One is the repeal of the prior ordinance. It's really important that you give consideration to this, and this is one item that's often overlooked. Keep in mind that when your jurisdiction passes an ordinance to adopt amendments to a code, that ordinance is a law on the books, and those changes will remain legally enforceable until such time that you repeal them. So since every 3 years we go through the process of adopting a new set of codes, it's conceivable that the prior cycle you adopted a provision and your jurisdiction may not be addressing that particular code section again if you no longer want that. You need to repeal it. The easiest way to see to it that you don't unintentionally carry forward amended language that you do not want to apply anymore is to include in your ordinance a provision that repeals the previous ordinance. In that manner, in one fell swoop, you repeal every action that you took the previous ordinance, and the effect of the new ordinance will not be affected. Another item that is very, very useful, that is sometimes overlooked, is to add a provision in there which addresses references to prior codes. And I actually have an example that I'll show a little bit later. The reason that this is important is give some thought. As a code official, you probably have a lot of forms in your jurisdiction that might make reference to a particular year edition of the code. Unless you are also going to go through your entire library of documents and republish all of those forms and put them out on your counter starting January 1st, there is a very, very good likelihood that you will be using documents that actually reference a prior edition of the code. By addressing this and seeing to it that references to prior code shall be interpreted to mean the current code that you're adopting, you can avoid those problems. And I'll actually have an example of that exact language. Okay, just want to go over some points that are embodied within the statutory law to see to it that code officials understand why they're doing what they're doing with respect to those justifications. And actually what the Health and Safety Code states is the following. The governing body of a city or county, before making any modifications or changes pursuant to section 17958.5, shall make an express finding that such modifications or changes are reasonably necessary because of local climatic, geologic, or topographic conditions. As the statute states, it's important that the justifications be made first. What this really means to you as a code official is that when you present these to your city council, the order in which they take action technically is important. Have them consider the resolution that justifies the action that they're about to take before they actually pass that ordinance. Also keep in mind that such a finding shall be available as a public record. Turns out that it's going to be available as a public record two ways. Number one, if you properly file those amendments and justifications with the Building Standards Commission's office, they will act as a clearinghouse. They file it and they keep a copy. They will not evaluate the propriety of those standards, but they will take a copy of it, and that will be available as a public record, thereby meeting your burden under the Health and Safety Code. But since you will have also taken action through your governing body, the records of that city council meeting will also serve as a public record. And then I want to point out that a copy of those findings, together with the modifications or changes expressly marked and identified to which each finding refers, shall be individually justified, and that's what you have to send to the Building Standards Commission. Every single amendment has to be individually and expressly marked as to why it's necessary.
Okay. So once your local jurisdiction has adopted the ordinance, it's filed with our office. The address is available here on the slide. But keep in mind, we talked a little bit earlier about certain amendments may fall under another state agency's authority, so it may be necessary to file your ordinance with them as well. Generally, when we receive the ordinances, we take a look at it, and if it is impacted by another state agency, we send it off to them as well. It's also helpful if you send it certified mail so you know that we've received it. You will receive a letter from us stating that we have received your local ordinance, and if it is acceptable for filing, the letter will say that. If it's not acceptable for filing, generally we reach out to you and we say, hey, you missed this and you missed that, and we offer an opportunity for you to send another copy. If it goes on for a long time, you may receive a letter from us that says it's not acceptable for filing, and we'll resolve it from there. What's happening lately with technology is we are required, due to SB 1442, which statutes of 2016, we are required any documents that are available on our website need to be accessible, and that's something you may want to keep in mind for your website as well. So what we are requesting is that your local jurisdiction, if you file it with us electronically via the email that you see here, is that it is a readable PDF format. And we understand that the scanned document that has the stamp and the date on it may not be readable. We can add a note to that so that it is readable on our website. If you send it to us via the email, we're probably going to have to just scan it in our office and post it, or we may reach out to you and say, hey, do you have a readable document on your website? We would like to link to your website so that we could have a readable document available. I want you to keep in mind that, again, we don't evaluate all of the criteria. We just merely are making sure that all of the expressly marked and findings are within the document. And there are no procedures at this point or rules on how you have to do it other than those express findings and justifications. All right, I think Stuart has some samples.
Thanks, Mia. At this point, we're going to go over some examples that hopefully will be useful to all of you code officials. We're going to go over an example of a city council staff report and resolution. We'll take a look at some useful parts of that adoption ordinance, which you may want to consider including within your own ordinance if you don't have anything like that. And then, because any amendment to a provision of the code that affects energy efficiency must also be filed with the California Energy Commission, we have some examples of exactly how that works and what those documents look like. This is an actual resolution, as I mentioned earlier, that in order to comply with the Health and Safety Code, a local jurisdiction must justify why they are about to amend something before they do the actual amendment. So the resolution should come first. And this is an actual copy of the resolution that's utilized by the City of Glendale in Southern California, resolution number 16198. This is the actual signed copy of the back sheet of that resolution, indicating that this action was taken by the City Council, signed by the mayor and the city clerk, and you can see that the city attorney reviewed this as well. This is important because earlier in the program, Mia pointed out that in order to take legal effect, this action must be taken by your governing body. It can't simply be a department policy by your building department. So here, the City Council actually adopted this resolution which justified all of the individual actions. In this example, what we see is this was further on in the resolution, and this gives some examples of how that particular jurisdiction justified each and every one of the local amendments for their code. There were actually several pages in this resolution, and as you can see, each and every code section that was amended was expressly identified, thereby marking them for amendment, and the actual justification follows each one of these. As an example, if you take a look at the second item on this particular sheet, it turns out that it was amendment number 48 for this particular jurisdiction. You'll see that they utilize as a justification a geologic condition because of the potential damage that could affect concrete and tile roofs due to the seismicity of this particular jurisdiction. And you'll notice that in this particular justification, they utilize a geologic condition and they indicate that they're using justification B in an attached matrix. So let's take a look at that matrix and see how it's tied directly to an express justification or finding. So here's that matrix. And we can see about 3/4 of the way down, amendment number 48 in the left column addresses this particular code amendment provision. And in the far right column, you'll see that the justification is identified as justification B. So this is expressly stating that for this particular code amendment, justification B is the reason that this jurisdiction feels that it is reasonable and appropriate. If you take a look at the key to the justifications utilized in this resolution, justification B indicates that this amendment is justified on the basis of a local geologic condition, and it goes on to state that this city is subject to earthquake hazards caused by its location on the Sierra Madre Fault, near the base of the San Gabriel Mountains. It goes on to indicate the effects of that earthquake fault, and so forth. So you can see that in this manner, this jurisdiction did not merely state that this code amendment is necessary due to a geologic condition. It goes on to state what that geologic condition is. And here's the first page of the ordinance for which that jurisdiction adopted their local amendments. It turns out that the city of Glendale is one of those jurisdictions that adopts all portions of the code within one ordinance rather than having separate ones, and that's perfectly acceptable. What's important to note here is that the codes that are being adopted and amended, are the California Building Code, not the International Building Code. As I mentioned, there are some things that are very useful for jurisdictions to consider while adopting their code. And here's an example of something that that particular jurisdiction included in their adopting ordinance that I'd like to bring to your attention. You can see about halfway down the page, they have a provision that talks about reference to prior codes. And in this particular section, it states that unless superseded and expressly repealed, references in city forms, documents, and regulations to the chapters and sections of the former Glendale Building and Safety Code, edition 2014, shall be construed to apply to the corresponding provisions contained within this particular ordinance. So this is a very good way to address the fact that you, as a code official, could have many different forms and documents that still have references to another code. So this is a very, very useful provision. Here's another provision that's very useful for you to consider including in your ordinance. Right in the middle of the page, this ordinance expressly states the effective date upon which the ordinance will take effect. This is useful because, as we saw when we took a look at the local adoption timeline, the date on which your council, your city council, adopts the ordinance is generally going to be fixed based on the regular schedule of city council meetings. Of course, there does need to be 30 days or more to avoid the necessity of an urgency clause, but what you should do is consider expressly stating that that ordinance will take effect on January 1st of 2020. And while you're adopting your local provisions, here is an example of an administrative provision which does not need to be justified, as Mia explained previously, because it's an administrative standard, not a building standard, but it's very useful. And I know of a lot of jurisdictions that include this exact language. In this particular example, we talk about the responsibility of the permittee. In this particular case, the city of Glendale includes this provision to expressly indicate that it is the permittee's responsibility to see to it that the work that they submit complies with the code, and even if they have a mistake or an error, it is their duty to see to it that the design that they submit and that the buildings that they construct are compliant with the Building Standards Code. And since we used as an example earlier an amendment to the code in which the city of Glendale had some additional attachment requirements for concrete and clay tiles, and you may recall that they utilized a justification based on a local geologic condition due to the seismicity, the proximity to the Sierra Madre earthquake fault. This is the actual amendment to that. Here you can see that the City of Glendale amended the table, which identifies the attachment for clay and concrete tiles. And in this particular case, what that city did was they amended the provision which allows a single nail attachment for clay and concrete tiles to require at least 2 nails. And in this last example, we can see that this particular jurisdiction chose to amend some of the appendices for application in its jurisdiction. And we can see that items 104 and 105 in this particular ordinance were amendments to Appendix F, which is not adopted into the California Building Code, and Appendix I, which it turns out is only partially adopted in the California Building Code. So as Mia already covered before when she talked about the appendices, if you choose to adopt an appendix into your local code, it's very important that you have a specific amendment that addresses that. And here are examples for Appendix F and Appendix I, how the City of Glendale properly did that for their jurisdictions. Okay, and one more thing that I want to go over right now is any amendment that you as a code official may be contemplating that affects energy efficiency. As I mentioned earlier, if you as a code official choose to amend any provision of the code at all, if it has the potential to affect the efficient use of energy within a building, you must have that certified by the California Energy Commission before you are allowed to enforce it. This is a step that is above and beyond the standard code adoption process. And so the City of Glendale, which is a very progressive city, does have some standards that increase the effective use of energy in buildings. And so I'm going to use this as an example to show you how that is done. It starts with a cover letter that identifies to the Energy Commission, in this case, Mr. Joe Lawyer of the Energy Commission, what will be submitted to him for review. In addition to identifying the specific code amendment, what is referred to as an energy cost effectiveness study must also be submitted. That's the basis by which the City of Glendale could demonstrate that it was reasonable on a cost basis. So in this particular case, the City of Glendale chose to amend the code to require radiant roof barriers in certain buildings where the standard energy code would not otherwise require it. So in order to justify it, there was this one additional step that was necessary, and that was to submit an energy cost effectiveness study. So as you can see, here we have the cover page of that particular study, which was performed by a company, Michael Gable and Associates. And they provided a study which ended with this particular conclusion. What they did was they took a look at the effectiveness of adding that radiant barrier to a structure and figure out how much energy it would cost. They identified how much the additional cost of adding that radiant barrier to the roof would be, and based on the offset in cost because energy would be saved, they identified that in 11 to 12 years, the cost of that additional construction material and labor would be overcome, after which, from that point forward, it was all energy savings. Basically, the conclusion ended by identifying that with a simple payback period of 11 to 12 years, it would more than pay for itself based on the climate zone, and therefore was determined to be an effective modification to the code based on cost. That was then submitted to the California Energy Commission, and after they reviewed it and took a look at the cost effectiveness study, took a look at the justification and the actual amendment, they then certified that as an acceptable amendment to the code that affected an energy standard. You can see that by resolution number 12-1114-1E, the California Energy Commission certified this, and therefore it was indeed enforceable. If you, as a code official, submit anything to the Energy Commission that affects energy efficiency, you will know that it is enforceable because you will receive a certification exactly like this.
Okay, every cycle, the Building Standards Commission updates its various guides to be in alignment with the code cycle. And this guide for local amendments of building standards complements the video that you have today. And in it, it contains local government responsibilities, local amendment requirements, applicable state laws, causes for rejection of a local ordinance filing, and which state agencies the ordinance should be filed. This is especially helpful for local jurisdictions who have not yet, prior to this cycle, filed a local ordinance.
And finally, this is an opportunity to talk about some other resources that are available to you in addition to the California Building Standards Code that you will all be adopting and enforcing. Some other model codes are available that could be useful for you to consider in your adoption ordinances. And here are some examples. The International Property Maintenance Code is a great resource that you might want to consider if you would like to add some additional standards for enforcement within your jurisdiction to provide guidance on how existing buildings and property should be maintained to see to it that your community is safe. The International Swimming Pool and Spa Code is another resource that, in addition to some of the standards that Mia is going to talk about regarding the legislative requirements that we all enforce that are related to swimming pools and spas, there are some other guidelines that you might want to consider to see to it that swimming pools and spas are constructed and utilized within your jurisdiction safely. And then, of course, California experiences tremendous wildfires during the dry part of the year. And then, in addition to the wildland urban interface standards that we have in Chapter 7A and Section R337 of the Residential Code, the International Wildland Urban Interface Code provides additional standards so that while our jurisdiction may experience devastating fires in some of our forested areas, if your community is interested in looking at whatever other code standards are available to bolster some of those standards, you may want to give that particular model code a look.
I think it is very important to keep in mind that the law prevails. So in the instance of the Swimming Pool Safety Act, which is in the Health and Safety Code, Building Standards Commission is required by law to reprint that, and we reprint it in the residential code as well as the building code. But the key here is it may not have enough regulations in it that you want for your local jurisdiction. And so that may be why you want to look at other resources or other standards out there that are available. And then Stuart really gave a great description of what's facing our state the last few years is the wildland urban interface standards that are out there. But you need to keep in mind you can't enforce anything less than what is in 7A. And in the Building Code, Chapter 7A, it actually points as well to the sections in the California Fire Code, as well as the Public Resources Code. So it's very important that you maintain those minimum standards and then enhance them as you wish with other standards or other model codes that are available.
And with that, me and I would like to thank you all for taking time to view this. Just in conclusion, if anybody needs to contact either myself or Mia, our contact information is on the last screen. And if you do need any assistance, Mia and her staff are available for a phone call or an email.